This is my very first YouTube video, and I'm doing it on a topic that is near and dear to my heart, and that is the prospect for the prosecution of George W. Bush and other members of his administration for crimes they committed while in office, specifically violations of international laws pertaining to torture. I'm doing this video as a response to Landon Cole's recent video on the same topic, and to some extent I want to make this video as a dedication to Landon. I have never met him, but I consider him a friend, and if anything I do on YouTube even approximates the kind of grace and intellect and good feelings that he brings to the work that he does here, then I would be very pleased. So I hope this video is accepted in that light and as an example of a way to proceed with constructive disagreement. The question before us, as stated, had to do with whether George W. Bush should be arrested. This is with respect to recent activity concerning his potential travel to Switzerland. I may address a more general question, and that is how aggressively should the international community pursue the prosecution of members of the Bush administration for crimes, alleged crimes that they committed in office, specifically with regard to torture. And I want to begin by saying that I largely agree with Landon's analysis, and that is that the immediate effects of pursuing George Bush in a foreign court or any other high-level Bush administration members would likely be very disruptive diplomatically. My guess is there would be all hell to pay, and there would be dire short-term repercussions specifically directed at any state or states that decided to initiate and pursue such a legal process. I do agree with Landon that there would probably be withdrawal of support from some international institutions, but I imagine because of self-interest that the U.S. would continue to participate in arrangements that it felt was to its relative advantage. So I don't think that it would shake the international framework to its core. I also imagine that any legal process that went forward to any extent would likely be disrupted by executive or parliamentary intervention of some sort, but I wouldn't necessarily require that to be a condition. I would like to see such legal process go forward. So the question that I pose is that granted these costs, why should we proceed with such a prosecution? And I'd like to answer that question just first by noting some historical background. And in summary, I would say that the history of the U.S. foreign policy in this regard is one of the doctrine of American exceptionalism. And the doctrine of American exceptionalism is rooted in relatively good reasons. The U.S. participated in World War II, and the country and its citizens consider that to be a triumph of its national history, and as a result, they have acquired a heroic self-concept that they fall back on in terms of justifying their approach to foreign policy and justifying the actions they take and supporting whatever foreign policy decisions they make. And this heroic self-concept is to some extent cemented during the Cold War and the long-standing opposition to Soviet domination of Europe and perhaps other parts of the world. The result of all this is that Americans and the American government have acquired what is could best be called an entitlement of freedom of action, and it's largely based on a paternalistic regard for divergent views. And this applies to allies who disagree with U.S. policies. They are at best looked upon as sort of limp-wristed Neville Chamberlains who want to appease dictators at a drop of a hat, or more disparagingly as cheese-eating surrender monkeys, to use the parlance of The Simpsons. Domestic opposition is not spared this type of criticism, and they are either considered misguided do-gooders, or more often these days fifth column traitors. And I'm sure I will get a taste of that in any comments or responses to this video, to the extent that people take the time and trouble to watch it. This idea of American exceptionalism has also been aggravated by decades of realpolitik, notably through Henry Kissinger and then his neocon foreign policy successors in recent administrations. And the net result, which is not news to anyone, is the U.S. is engaged in overthrowing legitimately constituted governments, political assassinations. Some of this is, of course, as Landon points out, has been addressed by the Church Commission. Other things have happened since the Church Commission. There was a mining of Nicaraguan harbors during the Sandinista regime there, and it was an overt act of war and in violation of international convention. But at that point in time, the world community was powerless to do anything against it. More recently, the U.S. has used its doctrine of exceptionalism to embark upon at best, a legally questionable war in Iraq. And that's the complexity of that, I believe, to other videos or other discussions. But one thing is clear, and that is that since 9/11, and also as part and parcel with the Iraq War, the U.S. has been unquestionably engaged in illegal activities with regard to international law, and that is torture, specifically waterboarding and extraordinary rendition. And all of this is in the pursuit of claimed national security and interest. So, given that background, and given the fact that there's, as Landon noted, a price to be paid for pursuing individuals of the Bush administration legally, why should we proceed to do so? And I believe that the answer is that it's time to turn the tide. It's really time to turn the tide on American exceptionalism. And I cannot imagine a better legal situation to do so. The torture charges make for an exceptionally good lesson. They're focused and largely undisputed by any fair reading of international law, except for the craven readings that were given by the Bush administration's own Office of Legal Counsel. Torture is universally regarded as a repugnant action. Hardly anybody can defend it. Even people who are quite nationalistic here find it difficult to come to the defense of using so-called enhanced interrogation techniques. Another reason why this is a wonderful case for international law is that the lines of responsibility are clear and documented. There's no question as to the fact that these orders came from the top, and the prospect of just following orders, defenses is not going to be an acceptable one. These were the guys giving the orders. More importantly, it's time to turn the tide, because it's not clear that American foreign policy with regard to reconsidering its exceptional role is changing, and this is an opportunity to do so. And in bringing that to a point, I really could justify pursuing these charges using two words or several sets of two words, and those are President Palin, President Romney, President Gingrich, President Huckabee. Take your pick. The fact of the matter is that future administrations need to be put on warning that such actions are unacceptable, and not only in a legal sense, but on the part of our friends, whose opinions we should trust. And I don't for a minute believe that Sarah Palin, for example, has the intellectual wherewithal to process these types of criticisms. But I do believe that the future John Hughes, who was the architect of the Bush administration legal policy on torture, and that other functionaries like John Woo in future administrations should be put on notice that the actions like this will be considered criminal. So in summary, I want to say that, first of all, prosecution of Bush-era war crimes will undoubtedly be diplomatically disruptive short-term. But there appears to be no indication that American administrations will alter their approach to the conduct of foreign policy without such a wake-up call. But more importantly, and that is that there are long-term benefits that will accrue from this. The long-term benefits having to do that the United States will finally become a good faith participant in a world governed by international law. And the advantages of having the most powerful military force and still the most powerful economic force in the world actively engaged in a constructive way in international law are incalculable. So that will offset a lot of the short-term disruptions, and I think it makes this a matter worthy of pursuing. Finally, and I just think this is really important. I think Landon talked about this a bit, and Uj, if I may refer to you as that, mentioned it also, the issue of deterrence. I think deterrence is really important, but I think it's more, it's broader in its impact, and that is that the legacy of Nuremberg and the Nuremberg trials, which is the foundation of a lot of international law, has largely been suspect because it's been characterized as victor's justice. And this is really a wonderful opportunity for us to show that the legacy of Nuremberg isn't that victors can dictate international legal outcomes for lesser potentates and people who violate international law. And I just think that it's essential for the expansion of respect for and trust in institutions of justice, of international justice, that these specific cases relative to the Bush administration go forward. So that's it in a nutshell. Yes, there'll be short-term disruption. Long-term benefits are really not only overwhelming, but they are essential. They are essential in the world as we go forward. And there doesn't seem to be a better time than the present to proceed with this. Thank you very much for your time and attention.